Hello, everyone. Welcome to Immigration and Jobs Talk Show. I am Nipasa Pradhan, and today we have a very incredible topic to discuss about. But before that, I have this important disclaimer on the screen. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, a very good morning, good afternoon, good evening, all you folks out there. Thank you for joining us wherever you joined us from and whatever time it may be. And like I was saying earlier, we have a very incredibly important topic to discuss today, and that is H-1B cap and visa bulletin updates. What you need to know for fiscal year 2025. And before we dive in, I wanted to welcome all our viewers once again, wherever you're watching us, whether it's Facebook, LinkedIn, or YouTube. Thank you so much for joining in. And I'm really glad you have joined us today. And you know what? You can also participate by commenting. So, whichever platform you are joined us from, don't forget to comment if you have any immigration related questions or especially questions related to the topic. Feel free to drop them. And yes, so joining us is someone who truly knows the ins and outs of immigration law. And she's a familiar face, joins us almost every Wednesday. So please help me help welcome her back once again. None other than attorney Prashanthi Reddy. Hi, Prashanthi. Thank you so much for joining us and welcome back to our show. How are you doing?
Hello, Nipasa. I'm good, thanks. How are you?
I'm also good. Thank you so much. Good to have you back, and I'm excited for today's webinar.
Same here.
All right. So, yes, friends. So I was telling you about today's topic. We are going to discuss about the September visa bulletin mainly, and Attorney Prashanti is going to lead us through. I also have some questions, and you too feel free to drop your questions. And yes, so I think without further ado, we should just go on to the topic. And Prashanti, what can our folks expect from today's webinar with us, before we start off with our questions?
Yes, so we will be talking about visa bulletins in general, how to look at them. We'll talk about specifically the September visa bulletin, what the changes are, if any, and also what to expect in the October visa bulletin, and some general questions with reference to priority dates and visa bulletins.
Yes, we are. So you heard it, friends, and feel free. So I think to break the ice, I got some questions as well. So Prashanti, my first question to you would be, what is the new priority date for the EB3 category for applicants from all chargeability areas, Mexico and the Philippines?
For the EB3, you said?
EB3 category, yes.
Oh, so with reference to September 2024 visa bulletin, EB3, all chargeability areas, Mexico and Philippines categories, all retrogressed by a full year to
Full
December
year, yes.
1, 2020. So they have retrogressed. India is still at October 22nd, 2012, but all other categories, meaning all other countries, including Mexico and Philippines, retrogressed. EB3 has retrogressed by a year. And that was expected because that's what they've been saying in the previous bulletins, that they expect
Mhm.
EB3 all worldwide to retrogress, and that's what happened.
Did. So I think many people are a little sad after the visa bulletin. I mean, the dates, there's not much changes. I mean, changes are there, but not to the better, I think, Prashanti. What do you have to say about that?
Um, yeah, so with reference to all other categories, they remain the same as the August 2024 bulletin. So the only change that we're seeing is that EB3 for all other countries except India and China have retrogressed by a year. Um, and also, not only EB3, but all other workers, other workers. So after EB3, this the next one is other workers. Other workers also have retrogressed, but by a short period of time, that is by 1 month. So all other workers are workers that don't require a bachelor's degree. EB3 is generally workers that require a bachelor's degree. EB2 is
Mhm.
workers that require an advanced degree, and EB1 is, multinational executives as well as extraordinary ability categories. So these are the different categories. We have EB4 and EB5 as well. EB4 is
Mhm.
religious worker category, and EB5 is investor visa category. So these are the different kind of employment-based visa categories and the priority dates, as I said. Just to reiterate again, EB3 has retrogressed for worldwide by 1 year. All other workers has retrogressed by 1 month for all countries. That is all countries, including Mexico and Philippines, but not including India and China. India and China, the dates pretty much remain the same for all the categories, in all the employment-based categories.
Okay, okay. So since you've already touched on this, next question I had was about India actually. So if you could tell us about the final action dates as well, for India in EB1, EB2, and EB3 employment-based categories, and have they changed anything from the previous month?
So, as another thing to mention is that the USCIS has said that they will look at the final action date table for employment-based cases and
Mhm,
the dates for filing table, which usually looks better for the family-based
mhm.
cases. So
Okay.
employment-based final action date table. And just to give you a difference between the two, the final action date table is the date when the priority date is actually current. The
Okay.
dates for filing table is when the USCIS expects that, or the Department of State expects that the dates will become current soon, but they're not yet current, but they're allowing you to file your cases in advance, and they're hoping that by the
Mhm.
time USCIS completes its processing, the dates may become current. So that's the difference between the two tables. Coming back to your question with reference to what the tables look like, or what the priority date looks like for India for month of September, as I said, there is no change. So it's February 1st, 2022 for EB1, July
Mhm.
2012 for EB2, October 22nd, 2012 for EB3. So EB2 and EB3 is in 2012 and EB1 is in 2022.
22. Okay. Okay, thank you so much, Prashanthi, for taking that up and for highlighting the final action dates for India as well. And moving on, now I got this next question for you. What is the current final action date for EB5 investors in unreserved categories, and has it changed?
It's current basically for unreserved. Actually, it's December 2020, December 1, 2020, for India. And for China, it's December 2015, I believe, December 15, 2015. So nothing has changed with reference to EB5. The only change is, as I said, EB3 and other worker category.
Okay. Thank you, Prashanthi. And I'll take this moment to actually greet my friends out there who have joined us on Facebook, YouTube. Thank you so much for your comments. I can see Akbar, hi, Vignesh, we have Priya. Thank you so much, Madihar. We will take up your questions and also Fagun. Thank you so much for joining us. I saw your question. We will take up in a short while. But for now, we're just brushing up on some highlights from the visa bulletin that came up recently for the September visa bulletin. So, moving on, Prashanthi, let's talk about what potential advancements or changes might applicants hope to see in the October 2024 visa bulletin, especially in the EB3 category?
The State Department confirmed that it expects to see advancements in the October visa bulletin. This is when the
Mhm,
new fiscal year starts. However, advancements, they said, may be modest US, given that USCI has previously said that it still has a significant number of applicants in its inventory for
mhm.
several fiscal years to come in categories already, that are experiencing backlog. And those categories are basically EB2 and EB3 categories for Indian nationals. So they're saying that may not be much advancement because there's already many people in the pipeline who are will then use up the visa numbers. So for people who are filing, people who are going to file, they won't see much change in the the priority dates. There might be some forward
Mhm.
movement as there always is. We just have to wait and see what that forward movement is, but it's not going to be sensational forward movement. It's going to be more of the same as last year. It'll move forward somewhat in October, November. They might use the dates for filing chart, which um, there's not much difference right now, unfortunately, between dates for filing and final action dates. Um,
Mhm.
but yeah, it's something. So they'll use the dates for filing chart for employment-based categories as well. And we hope EB1 will move forward more significantly for India than EB2 and EB3, because and hopefully EB1 will become current. Let's see, or might be
Mhm.
retrogressed only by a few months. Definitely not 2022. Hopefully it will come into 2024 or 2023. So let's wait and see.
Okay.
And we'll
And
we'll continue to we'll continue to give you updates, of course, as the new visa bulletins come out. So we'll and give you an analysis as well. But yeah, that's what I'm expecting moving forward.
all right, all right. Well, I also wanted to know your point of view about the family-sponsored green cards for applicants from India, which has it changed also on the September 2024 visa bulletin?
Not much change either way. And I don't have the bulletin in front of me, but there's not much of change for family-based
Okay.
either. But they are looking at the dates for filing table, and not the final action date table, so that's a little better. And we expect again, forward movement in October,
Mhm.
as there always is. So let's wait and see.
Okay, okay. Well, Prashanthi, like I want you to tell us about the significance of the dates for filing section. Sorry, dates for filing section in the visa bulletin, and how does it affect the green card applicants?
So as I was saying, there are two tables, dates for filing and the final action date table.
I know
And as
action
I
date.
was saying, that the final action date table is the date that your priority date is actually available, which means if you file your 485, and if they process it, and by the end of their processing, if the dates are still current as per the final action date table, then you will get your green card. For the
Hmm.
dates for filing, you can file your 485, and it will remain pending until your dates become current as per the final action date table. But you're allowed to file in advance. So you will get the benefit of EAD, and the advance parole. You don't have to maintain your
Hmm.
non-immigrant status. If you don't want to, you can get onto a 485 pending status. So that's the significance of the dates for filing table, which were introduced, I think, sometime in 2015, which have been a boon really for most people, because at least they don't have to depend on the H1, and they can get into this status called pending 485 status, which is not a bad status to have, because you can then work for any employer.
Right. Thank you so much, Prashanthi, for taking that up. And also, I think we should quickly take up one from the audience right now. And
Sure.
let's take up this one, Fagun, on YouTube, asking, my company filed for H-1B visa this March, and I got selected in the second round of H-1B lottery. I got my selection notice, and the notice date is August 3rd, 2024. What is the last date for me to file I-129 form?
You have to file it within 90 days, and your selection notice will say what the last date is. So most probably it'll be November 3rd or so, and you need to file it before that.
Thank you so much for taking that up for Fagun. Fagun, all the best, and congratulations for making it to the lottery also. And now let's take this one, Vignesh. Vignesh has commented on Prashanthi's channel. This question says, "Hi Prashanthi, a quick question. I haven't received any notifications from USCIS about the latest H-1B lottery. My employer also hasn't been notified. Does this mean my case wasn't selected?"
Yes, unfortunately, that's what it means, and because they have USCIS has said that they have done all the selections and that they have notified the results.
Mhm.
to the employers and the attorneys. So we can't expect that any more notifications will come by. So
Mhm.
yes, that's it. And the next step is basically they will send intimation that you have not been selected and your status in the USCIS registration portal will change to not selected. So you'll have to try next year again, and good luck with that.
All the best, Vignesh. And thank you so much, Prashanthi, for taking that up. This
You're
moves,
welcome.
me to my next question for you, which is pretty related to Vignesh's situation right now. And what are the possible outcomes of an H-1B petition, and what steps should be taken if the petition is denied?
Well, the possible outcome of a H-1B petition once you file it is you might get a request. Well, it might come back without being processed at all if you don't send it to the right service center or you don't sign where you need to, or if you have not filled out a particular column, or if the checks are incorrect. Any of these could result in the petition being sent back from the mailroom itself. So that's one possibility. The second is you might get a request for further evidence, which is called a RFE, and you need to respond, and you have a certain time to respond to that RFE. And once you respond to it, then you might get an approval or a denial. So it could be either an RFE, it could be a straight approval as well, without getting an RFE, or it can be a rejection from the mailroom. And of course, the first thing that will happen is you'll get a receipt notice, provided there's no
Okay.
rejection from the mailroom. If there's a rejection from the mailroom, they won't even process your fees. So you'll just get that entire package back.
Mm. Okay. Thank you so much, Prashanthi, for taking that up. And my next question would be, how can employers ensure that their H-1B employees are fully compliant with US immigration laws and regulations?
How can employers ensure that their employees are fully compliant?
Yes, that's right.
Yeah, so if they're on a H1, I'm presuming in your fact scenario that they're on a H1 because the compliances are
Hmm.
different depending on which status they're on.
Okay.
And if they're US citizens, they're completely different. So, um, there are obviously some general requirements from the Department of Labor that everyone has to follow. You have to pay them wages, you have to pay them on time, you have to pay taxes, etc., etc. But there are also some requirements that are specific for people who are on a H-1B status. So you have to pay them the prevailing wage as per
Mhm.
the labor condition application that was approved. They have to work at the work location based on again, the LCA that was approved. And if they're going to be moving from that work location, they should file for an amendment before they actually move. And again, you have to pay them every single day if they don't get paid. And if you bench them, then USCIS says that that's violating their H-1B status. If they're not working, then
Mhm.
they should be let go so that they can use the 60 days grace period and then file for a H-1B transfer. But you cannot not pay them and bench them and then still uh, you know keep them as your employees. That is really violating Department of Labor regulations. So I think these are a few things that you have to keep in mind. You also have some documentation requirements. You need to maintain the public access folder at your office for that
Mhm.
employee. If you're using E-Verify for your other employees, then you need to E-Verify them as well. Um, so and other documents has to have to be available for inspection. The labor condition
Mhm.
application before it's approved has to be posted for 10 days at your work site. So these are some of the things that you need to take care of if you're hiring a H-1B employee.
Right, right. And these days, anything can happen. So, do you have any cases to share with us or anything interesting to share where the employee maybe went through some fraudulent ways to get into a company and get employed, maybe? Anything that comes to mind?
Not not that particular case scenario that comes to mind, but there are
Mhm.
several other um, instances in which employers were had to face issues. Some of the common instances is if the employee doesn't tell them that they have moved and they move to a different MSA, different state, different county, then
Mhm.
they are out of status really, because then an FDNS officer comes and visits and they see that they're not at that where they said they were at that address, especially if the person is working remote. Then FDNS will send an audit and then they'll ask you to explain about all the employees that you have and this has happened. And that could lead to further USCIS audit, a DOL audit, ICE audit, and can become very nasty. So,
Yes.
that's an example of most common thing that happens. Employers don't file amendments when employees move, either because they forget or they're not informed by their employees that they have moved. And you also have to file taxes out of that particular state, wherever they're living. Sometimes that doesn't happen.
Mhm.
So I think that's the most common issue that I've seen with reference to not following the regulations.
Right. Thank you, Prashanthi, for sharing that with us as well. And let's move on now to another question. And what steps should applicants take once their priority date becomes current under the dates of filing applications?
Yeah, and since we're on the subject of the priority dates again, I just wanted to let you
Yes.
know that the State Department announced that the total annual limit for this year is
Mhm.
160,791. So that's the number of green cards that we have, and they have informed us that they are going to be using all the green cards by this month, and they're all set to do that. This is, of course, this green card number's availability is this for employment based, and this is down from last year. Last year there was 197,091 green card numbers available. And this
Mhm.
decrease is likely due to the surplus quota from the family based immigration visas not being available this year, as they were um, more available last year, and then they trickled down to the employment based. So, what can we expect moving forward? Since that was the question you had asked me earlier, also, how many numbers can we expect? I would think it would be the same as 2024. I hope it's more, but logic says it might be the same because nothing has changed. So let's see let's wait and see. But back to your question with reference to what to expect. Once your visa number becomes available, you have to file the 485 if you haven't filed it. And you have to file your 485 along with the I-140 approval. Presumably, your
Mhm.
I-140 is already approved. If it's not, then you can file it concurrently as well if your
Mhm.
visa number is available. And you also file your advance parole and your employment authorization document, which is I-765, so that you can start working once your EAD gets approved. And you need to file with all the proper documentation, the proper fees, send it out. I'm saying this over and over again because this is always a problem.
Mhm.
Send it out to the right
Mhm.
service center, the right address. It's a little tricky to find out what the address is because they keep changing it. The fees are also
Mhm.
tricky because they keep changing those as well, and it's not straightforward. So I
Also,
would
the forms.
suggest the forms keep
Yes.
changing, so you have to make sure you use the latest version of the forms and ensure that all the forms are filled out correctly with the accurate information. Make sure there are no discrepancies with your labor cert and the 485, the I-140. Everything should say the same thing with reference to your address or your previous employment. That can sometimes cause a problem if there's a discrepancy. And make sure you sign and you date all your applications and you send out the correct fees, and
Yes.
submit the proper documentation required to for your case to get approved. Of 485, there's a list of documents. Make sure you submit all of those, otherwise you will get an RFE. If you are submitting documents that are in a different language, make sure you get them translated into English, like a birth certificate, for example. or a
Mhm.
marriage certificate, um, because they won't, USCIS does not accept untranslated documents if they're in a foreign language. So keep all that in mind and you should be good to go.
Thank you so much. And so, folks out there, once your priority date becomes current, you're surely going to get very busy. So, get ready for that. And well, you're lucky if your dates have become current because that's not the case for many. So, all the best. And also, friends, we have so many questions. I will take up some of your questions very soon. And you keep commenting wherever you're watching us from. We are streaming live right now on YouTube, LinkedIn, and Facebook. So feel free to drop your questions. All right. So moving on, Prashanthi, what about how are the priority dates established? Since we have been talking about priority dates, final action dates all the time, and tell us how do they establish these dates? For family sponsored and also for employment based preference visas.
Well, it's the same for both. They will allocate a certain number of, well, the actual number of employment based, for example, visas available every year is 140,000 for the entire worldwide.
Mm-hmm.
Then they divide this 140,000 into 7% for each country. So each country gets 7% of that 140,000, right? So then, depending on how many cases have been filed, the priority date is established. So if there is more demand than there is supply of the numbers, then obviously you will not, it's backlog. There is a backlog that's established. So they establish that backlog, and that backlog date is the date when, after which you can file your green card. That's called the priority date. And
Mm-hmm.
that is published every month in a visa bulletin. Uh, in addition to the 140,000 numbers that are available, as I just told you, there are numbers that trickle down from family-based cases and also trickle up and down from the employment-based category, from one category to another, from worldwide to India, etc., etc., because wherever there's a backlog. So based on that, they have said that the total number of employment based green cards available for this year is 160,791, which is down from 197 last year. So that's how the numbers are established, and that's what the priority dates mean.
Okay. Thank you so much, Prashanthi, for making that very clear for us. And I hope folks out there know now how the dates are established. And well, also, I have some more questions, but I think we should quickly take one from the audience right now. Um, which one should that be? Siva Krishna from LinkedIn. Thank you so much for your question, by the way. She asking, can you explain about asylum fees and to whom it is applicable?
So all the employment-based non-immigrant petitions, HSLs, the employers have to pay an asylum fee, and this the USCIS has said is so that they can cover the asylum cost, which is some things that they do are not funded, and there is no fee for
Mhm,
them. So they're trying to cover the cost this way, which is extremely unfair because they're targeting one set of their stakeholders in order to benefit another sector of the stakeholders, which doesn't make sense to me at all. But the asylum fee is $300 or $600, depending on if it's a H1, depending on the size of the company. If there are 25 or lesser employees in the company, then it's only 300. If it's over 25 employees, then it's 600. So all employees have to pay this fee.
mhm,
Yeah, so it's a new fee which was established this year, and
mhm.
that's another thing that we have to worry about now.
Yes, surely. So, friends, I think right now it's time for a short break, but we are here for some more time, another half an hour to go. You can say a first half of the webinar is over. But thank you so much for your questions, and I will take up some of your questions right after the break. But also feel free to contact attorney Prashanthi Reddy directly if you want to consult an attorney. Why not consult her? Her phone number is 212-354-1010. Once again, I repeat, 212-354-1010. That's attorney Prashanthi Reddy's number. Note it down. You can even email her at prashanthi@reddyesq.com. Please check out for the spellings on the screen. Prashanthi@reddyesq.com. And also don't forget to go visit our website, reddyesq.com. And don't go anywhere. We'll be back to talk more about the H-1B cap and visa bulletin and the latest updates here on Immigration and Jobs Talk Show right after the short break.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I am Nipasa Pradhan, your host for today. And this is the second half of the webinar we are having on H-1B cap and visa bulletin updates, what you need to know for fiscal year 2025, with none other than our guest for today, attorney Prashanthi Reddy from the law offices of Prashanthi Reddy. So, Prashanthi Reddy is the founder and a leading immigration attorney of this law office. And she has a special focus on business immigration for IT, healthcare, and other industries as well as family based immigration. So, we are really very thrilled to have Prashanthi here today and really nice to get your insights. Thank you so much, Prashanthi.
Thank you for having me.
All right, so moving on. I mean, there are so many questions. I think Prashanthi will take up some from the audience right now, if that's fine. So I got this next question from Drive. Sorry, let's take this one first. Bhanu Prakash. Is amendment necessary for location change more than 50 miles or just AR11 is fine?
Um, yeah, so amendment for location change. So it doesn't matter. What they look at is if you're not working at the LCA location, are you working within the same metropolitan statistical area? Especially, we're talking about not your address, but the work location. So if your work location happens to be your address, then yes, if you change your address, that means you've changed the work location. And if you've changed outside of the metropolitan statistical area, then you have to file an amendment. So it doesn't matter how many miles it is. Usually, if you're in the same county, you would be in the same MSA. Sometimes a metropolitan statistical area covers more than one county. Sometimes it might cover two counties. So you really have to go up and look up, go and look up whether if it's in the same MSA or not.
Okay. This was on LinkedIn. Thank you so much, Bhanu Prakash, for your question. And I hope you got your answer. If you have more questions, feel free to keep commenting. All right, let's move on now to this next question. This is from Drive. Hi, Prashanthi. I entered the country in 2006 with an I-94 form. It expired 1 month after I stayed. Am I eligible? Eligible
Eligible,
for, I'm not sure. That's the
it
question.
expired. So it looks like the I-94 expired 1 month after, and they stayed back. So they might be out of status, but they're asking if they're eligible for a green card. We're going to presume that and say that no, you're not, because you have in order.
Okay. Drive, I hope you got your question, but just in case you need more clarity, please feel free to keep commenting. All right, now this next one, this is from Yash. Yash, also on YouTube, is asking, I am currently on F1 OPT, cap period. I have my H1B visa approved, which will activate on the 1st of October. I got an offer from another company who are willing to sponsor the H1B visa transfer. The question is, can the new employer start the LCA filing process and preparing my H1B transfer case before October 1st and then submit the H1B transfer petition after October 1st when my H1B is activated?
Yes, but the optics of it don't look good, because you're filing, you're joining a company just for one day, uh, and then leaving that company and transferring to another company. So the USCIS might say that there was no valid job offer to start off with. So I would
Mhm.
think that just, I mean, it may not be a problem. USCIS may not even notice all this, but just to be safe, I would just say that to do everything after you start working. And in fact, it would be best if you did it after you got your first payroll, so that you can show that you are on a H1 and you are in status and you're filing for a transfer, if that's what you want, if a transfer is what you want to do.
And also you're trustable and someone you can count on. I think that's what you will be proving if you stick to it. I mean, yes, yes. But if you have more questions, we are here. All right. So let's move on now to another question from the audience. Bhanu again is asking on LinkedIn. I work remote. My location is my residential address in LPA. If I want to change the residential address, what's the process to be followed in this case?
As I said, you need to file an amendment. Your employer needs to file an amendment. And once the amendment is approved, then you can move. An amendment is
Okay.
a H1B petition. It's exactly the same as a H1B petition. There's no difference.
Okay. All the best, Bhanu, and I'm sure it's not going to be so difficult. Just follow the rules and let's go on to the next question now. Ishwar, 2 years ago, I petitioned for my siblings. My question is, can they still apply for a tourist visa to visit the US while their petition is pending?
Yeah, that could be tricky. If you filed an I-130 for your siblings, then there is an intent to immigrate right there. And
Mhm.
so if you apply for a visitor's visa, they may not give it to you.
Okay.
So good luck with that. And you can't hide the fact that the I-130 was petitioned. There is a question, I think, in the DS form
Mhm.
as to whether you filed an immigrant petition, or they might ask it at the consulate. So your chances of your sibling getting a visa is slim, but you never know.
Okay. All the best. I know it's a very tricky situation, but I think you will make it through, Ishwar. So all the best. And I mean, if you need more, I mean, how to say, you need to consult an attorney, then I think it would be best to get expert advice directly regarding your case, which may be very special. All right, moving on now. I got this next question on the screen. This is from Priya Patel. Ma'am, I have a question. That is, one of our students on OPT has picked up H1B in 2023 March lottery, and he did not get confirmed. Sorry, and he did not get confirmed the H1B till today. And again, he has applied in 2024 lottery and got picked, but not got confirmed till today. What is the situation? Please clarify.
Can Priya clarify what she means by not got confirmed? Has she filed the
I think she's
H1B?
talking about the status.
Has she filed the H1B and she did not get a receipt? or she got a receipt but did not get an approval, Priya, just text us and we will get back to your question.
Thank you, Priya, for your question. Please give us more clarification. And we will move on now to the next question. This is from Sanjay. Hi, my I-140 OW receipt notice has an incorrect birth date and surname showing 1 day earlier than my actual date. Please advise.
Contact, ask your employer to contact customer service and get it corrected, because you don't want the approval to have a wrong date. It's okay if the receipt has it, but the approval should have the correct date.
Yes, will it cause any problems in the future? Of
It
course,
could.
I think
So
it
you
would.
have to get it
It
corrected.
could. Okay. Thank you so much for taking that up for Sanjay.
You're welcome.
This next one is from Mahinder. Have you ever won a 212H waiver for an aggravated felon? There are a few case laws of guys who were able to get a 212H waiver after losing their green card and serving prison time for a for an aggravated felony.
Mahinder, I don't do immigration. I don't do too much of immigration, so I can't say that I have filed something for an aggravated felon and gotten an approval, but I have done other kind of waivers,
Mhm.
and there are certain considerations for filing a waiver if you are if you have a felony. You have to show, in order to file a waiver, you have to show that extreme hardship, etc., or you have to show that you have a U.S. citizen relative, immediate relative, and you have to show the hardship to that family member.
Okay.
But it is possible. It is possible to do, but it
Mhm.
depends on a case by case basis.
Okay. So all the best, Mahinder. I hope you, why don't you get an expert advice? I think you should definitely go consult an attorney. And if you do want to, maybe why not reach out to us? You can also write to me. My email address is nipa@higherightpeople.com, and maybe we could, help out on trying to get an answer for you. All right. So yes, my number is also displayed on the screen. You can note it down. But I think it's time now to take up another question. This is from Fagun. I think we've taken this. We took this already. We've taken this, the first question we took. But there is an additional info. Fagun has said that additional info about her is that I was on OPT, applied for STEM OPT on April 20th.
Is there a question that we didn't answer?
No, I mean, we've answered her question, but she's giving more information. So
Currently
she
in
says,
UK
thank
due to fund.
Okay.
We didn't take up these questions actually. So let's
No,
take
we
it
did
up.
not take up this one, yes. So I am currently in UK due to family emergency. I have to stay here for a couple of weeks. Can I file while I am outside the US, or should I wait for me to move back to the US? My job is remote, so I'm currently employed and working.
And she's on an F1. Is that her follow-up information that she gave?
The follow-up information is she was on OPT and she applied for STEM OPT on April 20th.
I was on OPT and applied for STEM. Okay. So yes, you can file for a H1 counselor processing with a start date of October 1st or later if you've been picked in the lottery process. And once you get the approval, it can be mailed to you, and then you can go to the consulate and get a H1B visa outside the country.
Okay. Thank you so much for taking that up for Fagun. Yes, so Fagun is he. So sorry if I said she earlier. Thank you so much for taking that up. And I think we will move on now to the next question. This is from Yash. Does the H1B transfer LCA filing before October 1st have any consequences on my currently approved H1B?
Is this the same person who asked the question earlier about I think it is, and this is a follow-up question. Um,
Yes.
it does not have any consequences on your currently approved H1, but when you file for a transfer, there might be questions raised as to whether, um, there was a valid job offer or not. Why did you join company A and then immediately move to company B when you knew that you were
Yes.
not going to work for company A? So it's obvious, right? Common sense.
Yes. All right.
We're only talking.
All right.
We're
Yeah,
only
sure.
talking about. We're only talking about the optics here, how USCIS is going to view it, and whether USCIS is going to believe that you had an actual a valid job offer with company A because you only worked with them for one day and you had decided even before you started working for them that you're going to work for another employer. So it looks like you're gaming the system here, and USCIS does not like that. Whether they're going to comment about it or say, or do anything about it, that's a different story. We don't know that.
Okay. Very tricky situation for Yash, but all the best, Yash. I know you will figure out. Now the next question, I think let's take this up. This is from Matrix. How to do H1B?
I think that's a very, very broad question. So let's skip to the next question.
All right, I know. Well, Matrix, I would just say that please subscribe to our channel. We have a lot of things we've spoken about with many different experts out there. So check out what is an H1B and how to go about it. All the best. Now, this one is Lalasa on YouTube asking, I have my PD in September 2024 in the state, but now out of state with valid EB1, EB2 visa. Can I enter the state before my due date to apply for green card?
Does she mean the states or does she mean a particular
She means
state?
the
Is not
states, I think. She means the states, I think.
United States of America? Is that what she means? Um,
Lalasa, maybe if you could just tell us, yeah, let's
with valid
assume that she's
EB1,
saying,
EB2 visa, can I enter the states before my due date to apply for? I mean, you can enter the United States on another, visa petition, on a non-immigrant visa petition, on a H1 maybe, perhaps. And then once you
"Mhm,
come in, you could then file for a green card when your EB1 or EB2, whichever it is, priority date becomes current. But you cannot enter on your I-140 because that doesn't give you status, and you cannot file for a green card unless your priority date is current. So you cannot enter using that EB1 or EB2 I-140 approval that you have
mhm."
unless it's current and you filed an immigrant visa petition at the consulate and it has been approved and you have a green card.
Thank you so much for taking that up, Lalasa. I hope that answers your question. If you have more questions, you can keep commenting. All right. So now the next question. This is from Charan. Okay, from Yash again. I am working for company A on F1 OPT. That
For a
is
year
his
now.
initial
Ah,
information for a year now.
right.
Yes.
Right. I mean, it's up to you, Yash. Again, um, my feeling is it's better to do the LCA later. Wait, because it takes only 5 days to get an LCA approved, and you better to stay on the if you're filing a transfer, especially better to stay with the employer, get one pay stub, and then file the H1. Another attorney might disagree or might say that it's fine, but there's no
Mhm.
exact rule for this. It's just about perception. I see that you did work. You are continuing to work for your previous employer, so it's not like you are just starting to work for them. But I would still say that it's best to file for the transfer at least after you get the one pay stub, so that you can prove to them that you're currently on a H1 and you're in status on a H1 and you're getting paid the prevailing wage.
There you go. Yash, thank you so much for your questions. I hope, I mean, you've got some clarity regarding your case. And if you have more questions, please feel free, even though if the stream is ended, feel free to keep commenting because we will have our experts answer to you. And that goes to everyone watching. All right. So now this is from Vishnu. There are two questions. Now, this first one, what are the documents required for H1B consular processing from India? for I-797B approval?
So when you apply to the, I go to the website and book your appointment. USCIS will send you an email with the documents that they require. Usually, the documents required are your entire I-129 petition. It's a good thing to carry it. Of course, your I-129, the original approval, and an employment offer letter are some of the basic documents that they'll ask you to submit. If they need anything else, they will email you. But in general, I think those documents, and nowadays they're not allowed to ask for the end-client letter or the PO work order, etc. But sometimes they do, so I would just keep that ready just in case, and just follow their instructions in their email.
All the best, Vishnu. And moving on to the next question from him. Do we have to carry any money, like $500, to pay the US Embassy for fraud prevention fee?
No, that doesn't apply for a visa. That applies when you're filing the H-1B, not when you're going to the consulate for a visa. They have a separate visa fee, and they will give you instructions on how you need to pay it. They may take credit card or they might accept checks. So just look at the instructions in the email. I don't think they'll accept cash. I doubt it. Very few people do,
Yes.
but follow the instructions on the method of payment.
Right, right. So it's very important to follow all the rules, regulations, instructions while you're dealing with any visa. I mean, everything is a process and it has to be done on the right way, in the right way.
Correct. Correct. Yes.
This is from Charan, this next question on YouTube. My PD is March 10th, 2023, and visa is maxed out in December 24. Is there any possibility if EB1 date for India will become current to me in October 24 bulletin?
Who knows? It might. It's just speculation, right? So I would look at the visa bulletin last year, last October, to see what it was and maybe expect the same thing to happen. EB1 has been current for many, many years and then became, retrogressed. So 2023, yeah, you have a good chance of it advancing to 2023 from 2022. So, just keep a watch out for that in September. You should be getting the visa bulletin in the beginning of the month, usually in the first week. But since it's the October visa bulletin, they might delay it a little bit. You might get it in the second week of September.
Why would that happen? I mean, for October. Why not in the
Because they
first
might
week?
want to, it's a new fiscal year, so they might want to look into things more carefully
Right.
and take their time to decide
Mhm.
before they publish the visa bulletin.
All right. So it's always good to stay hopeful and think positive always, friends. Good things will come our way. So all the best, Charan, also. This next question is from Arjun. I have a question regarding my EB2 NIW visa application for entrepreneurship. I am currently not employed, but am running my own business. Should I include a letter from my company on company letterhead detailing my job role and current status within the company?
If he's not working, I'm not sure how he can include a letter. Did he say previously that he's not working?
He's running his own business,
Right, so then he's not working for any other company. Can you
but
go
he's
back to
working
the
for his
previous thing,
company.
please? Can you please go back to the
I
previous?
have a question regarding EB2 NIW visa application for entrepreneurship. I am currently not employed, but am running my own business. So
Would be nice to know
self-employed.
what.
I mean,
It would be nice to know, Arjun, what is your current status? Because there are very few statuses that will allow you to be self-employed. So I'm curious to know what is your status. Also, EB2 NIW is a vast subject, but you have to show that you have uh, exceptional ability in whatever you're doing. And there are many, many things that you have to include, not just a letter from your company. to show that you're exceptional, you're an exceptional entrepreneur. So I would suggest that you, go to the USCIS website and check out the criteria that they have for EB2 and IW. They have it detailed really nicely. But in order to show that you are above the rest as an entrepreneur, you have to show how successful you were. You have to show that you did something that will benefit the US economy and how it benefits it. You have to show maybe if you have press on your company, if you have discovered something, your company has discovered something, or you have patents, you've received awards as an entrepreneur, you are part of a prestigious group of people, which is difficult to get membership in. These are a few things that you can look into for the NIWEB2.
Great. All the best, Arjun. And I think this is a very special case, and I think we would need more to know how to go about this. This next question on the screen is from Neha on YouTube. My wife's I-130 went down but to 1 day and then went back to 5 months and is now back to 2 months and still nothing else needed this time. Needed ST. Okay, at this
At
time. Why is she being delayed or reset?
I don't know. We have to ask USCIS. And I understand your anxiety. But that's what USCIS does. I mean, their processing times keep changing. So you have to follow closely on their processing times.
Mhm.
Maybe they want to send you an RFE. Maybe they need some further documentation. Or maybe they just
Mhm.
backlogged. Who knows, right? But processing time for USCIS does keep changing. So there's nothing new or surprising in that. So you just have to wait for them to approve it.
All right, all right. So, do we have any more questions from the audience? I think we've taken most of them. Let me just have a quick look. Okay, thank you so much for. I think we've taken most of the questions, but I have another question to go, Prashanthi. And if you could tell us, how should applicants proceed if their visa category becomes unavailable due to reaching annual limits?
Well, this is if the green card category, I'm presuming you're asking about. Um, if the green card visa category becomes unavailable, um, yeah, which is not something surprising, it is unavailable for a lot of people.
Yes.
You just have to ensure that you maintain your non-immigrant status. And luckily, if you're on a H1, you can continue to be on a H1 once your I-140 is approved. There is no
Mhm.
term limit once the I-140 is approved. You can continue to get 3 years of extension on your H1, and that should be a way for you to maintain your status. Similarly, with the L1, unfortunately, there's no such thing. So you would have to then switch to a H1. So, whatever status you're on it for the long term because visa numbers are unavailable. So you have to try and maintain your status.
Thank you, Prashanthi. Thank you so much. I think we are almost reaching the end of our session today. It was very insightful and very detailed, and we could I'm very happy today because we could take up, I think, all the questions from our audience as well, and also mine. So thank you so much, Prashanthi, for very enthusiastically taking up all these questions we had for you. And maybe before we leave, if you could just wrap up and maybe tell our audiences out there, viewers, what can they expect in this next half of August and also in the coming month.
Well, there's not in August, it's going to be the same because the visa bulletin is already out. September also, we know what the visa bulletin is going to look like. October, we don't know as yet, so we are waiting and watching to see. We know it's going to be better than September, but how much better is something that we need to look into. Once we get it, most probably EB3 will not be as retrogressed. EB3 will move forward. We're hoping there'll be some forward movement in EB1 and also EB2 and EB3 India. Is heavily backlogged, so there might be some forward movement, but not a lot, is what I'm expecting. So let's wait and see.
Yes, that's all we can do. Wait, see, and stay hopeful. So, friends, all the best. And with this, we will wrap up our show for today. It was really nice having you with us, Prashanthi. We spoke about H-1B cap and also most of the updates on the visa bulletin. So, thank you so much for covering that up for us. And it was really a pleasure and an honor to have you once again with us.
Thank you, Nipasa. As always, it's fun to be here and to answer everyone's questions. I really enjoy the audience participation. They're so active on this channel. So, looking forward to seeing you guys again next Wednesday.
Absolutely. Our Wednesdays only feel complete with you, Prashanthi. Thank you so much for joining us.
Exactly.
You have a great day ahead.
Thank you.
Thank you, viewers, as well. Thank you for joining us on YouTube, LinkedIn, and Facebook. We enjoyed your questions, and Prashanthi as well, very enthusiastically answered your questions. But like I was saying earlier, if you're still watching this after the stream has ended, please feel free to keep commenting because we have our experts who would be very happy to get to you with good answers. So, all the best, and thank you so much for joining us today. We have another webinar coming up in an hour. So, which is going to happen. So, stay tuned to our channel, Immigration and Jobs Talk Show. And if you haven't already subscribed, please don't forget to hit the bell icon and also connect with us, follow us in all the platforms, YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Thank you so much for joining us. And yes, feel free to contact Attorney Prashanthi as well. I mean, if you want to have a one-on-one discussion, feel free to contact her. Her number is 212-354-1010. And also don't forget to visit our website, Prashanthi. Her website is reddyesq.com. And also me, friends, if you're looking for project placements, green cards, EADs, anything related to immigration and jobs, feel free to contact me as well. And my number is 408-335-6444. And my email address is nipa@higheritpeople.com. And to get to know more about us, visit us at www.higheritpeople.com. Thank you for watching. This is Nipasa signing off for now on Immigration and Jobs Talk Show.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@higheritpeople.com